Hello, welcome to the show. My name is Martia Umar, and on today's edition of the program, we'll be taking a look at something that concerns quite a number of people in the country and even beyond. So, we'll be looking at termination of a contract of an employee and what is accrued to an employee or they're dependent upon death, a disability, disease, or injury as a result of working. Maybe you're having to work for a company and this occurs. But we'll be looking at this in line with the Compensation Act, that is the Employee Compensation Act. And to discuss that with me, I've got a legal practitioner in the studio. We have Yemi Olaniyan Esquire. He is the lead partner, Lehi Attorneys, here in the Federal Capital Territory. Thank you so much for being here.
Thank you for having me.
These matters keep going on, and you'd be surprised. A lot of people are going through a lot when it comes to working or the working environment in the country. So when we talk about employers-employees relationship, we know that the Labor Act covers for all of this. But we know that, having said that, we know that employees have rights. We have the employers as well who also have rights. And then you're talking about termination, because at some point something might happen and it might lead to termination of a contract of an employee. So on what grounds should we have termination of a contract of an employee?
Okay, thank you very much. So I think before we get to termination, which brings me back to the point that it's important that you have an employment contract. Because when you have an employment contract, that your rights for wrongful termination can come in. So the Labor Act, Section 7, provides that every employer must give the employee an employment contract in writing within 3 months.
Okay.
So, and the law states what will be contained in the employment contracts. Issues from name, address, time, resumption time, closing time, workplace, salary, probation if necessary, leave, and termination. Now, so termination. The Act provides for 3 ways by which an employment can be terminated. So if you look at Section 9, Sub 7 of the Labor Act, it says, number 1, if it's a contract employment, that's a contract employment where parties have stated that this employment is going to last for 6 months. So at the expiration of 6 months, that employment terminates unless renewed.
Okay.
The next is by death. If the employee dies, the employment is being terminated. Lastly is by notice. So if assuming you're resigning your employment, you drop your notice that, on so and so day I'm leaving. Or if your employer is no longer satisfied with your output, you can say, it's time for you to go, and gives you a notice for you to leave the employment. So termination is backed up by law, yes.
Okay. So is there a time frame for termination of contract, maybe giving notice to the employee before the termination has been done?
Yes, I would say yes. The Act provides for a time frame for you to give notice of termination. So Section 11 of the Labor Act specifically provides the time frame. And I'll try to remember each of them. So for a weekly employment, it says you're supposed to give 1 day's notice. For an employment that is between 2 weeks to 3 months thereabouts, just give 1 week notice. Now, when the employment is between 3 months to 2 years, you give 2 weeks notice. When the employment is 2 years, 5 years above, then you give 1 month's notice.
So when you're saying that, 1 day notice for
a weekly
employee, are you saying the person can just be called into an office or even asked to leave like immediately? Are we talking about 24 hours?
Yes, 24 hours.
Okay.
So since it's a weekly employment, I can't give you a week's notice for a weekly employment. But again, I must say, what the Labor Act provides is just a guide.
Okay.
The Labor Act serves as the benchmark for the employment relationship. The parties can vary it. So the employer can increase it to 1 week, say 1 week. Maybe I can even make it 2 weeks. I mean, but like if it's a weekly employment, so you can make it whatever you want to make it. So the act just gives a benchmark. Parties are free to make their own decisions or they make their own specifics with regards to their employment contract.
So I'm just asking for clarification again. You say 2 to 3 years or 2 to 5 years. You mentioned years.
Yes.
Can that be for a contract staff who a specific number of years have been mentioned in a contract, or it has to do with maybe a staff of a ministry or in a public sector or in a private sector who there's no specific years accrued to that employee?
Again, we fall back to the employment contract.
Okay.
So irrespective of what the act has said, the employer and employee can make a decision that, okay, yes, it's a 6-month contract. We can decide that we'll do 3 months notice or we'll do 1 month notice. The act is not going to force you to do anything. The act just serves as a benchmark. Don't go below this for this employment. So for a contract employment, parties are free to make their decision as to what they want to be the notice period for the termination of their employment.
But when you are in a workplace, a lot of things happen, and getting to that termination time, the HR department, the organization, your colleague, a lot of things happen, and then it makes employees make some kind of decisions. Like, I'm going away, I've got a job somewhere else, or I just want to leave due to personal reasons, and I'm not just going to give a notice. What's the implication of that?
The implication is you have breached your employment contract, and your employer can sue and claim maybe damages and claim for breach of contract and all that. So it's I've handled a case where the employee left the employment, did not resign, did not give salary in lieu of notice. So that's another option. So is that you give for example, if it's a yearly employment, you can say, okay, 1 month notice or 1 month salary in lieu of notice. So you could do either. That's if your employment contract permits that. So in this particular case, the employee did not do either of that and left, and the employer sued. So your employer can sue. Most people think that it's only the employees that can sue the employer to court, but no, the employer can actually sue because if the employer does not sue, it will keep on happening. So Mr. A resigns without dropping notice. Mr. B wants to resign. We say, okay, since Mr. A did not drop notice, it means I can also up and leave. And to affect the company, to affect the mode of operation of the company, is now to show the company as unorganized. So it's important that there are checks and balances. If the employee resigns or leaves your employment without dropping a notice, then you can sue, call him back or tell him, man, because attached to your notice is your exit procedure.
Okay.
Because if you're exiting an organization, some organizations have exit procedures. Your line manager, your supervisor will sign to ensure that you're not leaving with company documents and you are checked out properly, to ensure that your company file is in order, to ensure that you hand it over properly. If company documents are with you, you hand them over back to the organization. So that's why that notice period is good. It gives the organization enough time to debrief you and for you to hand over properly. So if tomorrow they don't come and say, oh, you left our company document, you say, I signed my exit form and I signed all handover documents. So it's important that employees do not just up and leave, because your organization might be a very serious organization and take it seriously if the organization has serious HR and an admin department.
Okay, so when we're talking about things like this, are there exceptions? Because some people might give excuses like, when I give notice, I've seen other staff, former staff of the company give notice, and the last maybe few months or 2 months, it depends on the contract, as you have educated us, it's not going to be really smooth for them. They either look for one, maybe something you've done before, and then they get to let you go, or let's say sack before the day you were supposed to leave the company. Maybe that could be reason why they don't give notice. So could that be an exception to this?
There's no exception, right? And this is free legal advice. If you feel that your employer is very vindictive, You can do a salary in lieu of notice.
Okay.
So instead of you having to stay for the whole 1 month,
Mm.
you pay the salary for that 1 month, and then you can leave immediately.
Okay, so I'm going to leave my salary for a whole month
Yes.
just because I do not want to go through that
That
stress.
stress.
And I have to work for it. I have to work. I have to give
work,
that
yeah,
1 month, and then I have to forfeit it. Then who's going to pay for all of the expenses I've made in that month?
So it's the devil and the pussy.
Mm.
Whether you want to stay for 1 month, you're ready to give up your salary in lieu of notice.
Okay, so when this happens, employers would necessarily go to court. So what's likely the judgment when they get to court? Because people would love to know. Okay, so if I get there, am I just going to forfeit maybe 2 salaries, or I have to return back the salaries? What's the option?
So it will depend on what the employer is pleading in his pleadings before the court.
Oh, he could go further by
Yes.
saying not just.
Yeah, you could say, you could bring issues of, you've not been diligent in your duties, you caused the company serious loss because you didn't do this and this. So you might be claiming a whole lot more than just the salary in lieu of notice. So it's not advisable to.
Okay, so like Yemi Olaniyo said, Esquire, he's actually giving legal advice. We would say free legal advice on this episode. But we would like to go for a break. Don't forget, the conversation continues shortly. Do stay with us. Welcome back. Thank you for staying with us. It's still Law and Order on Trust Television. And today's edition, we've been talking about termination of employment contract. And of course, we'll delve into compensation right now, employee compensation. We talked about the Employee Compensation Act as a very integral part of working in a workplace, because at some point you find yourself needing to be compensated, either because of any form of injury, disability, even death, because some of these things are inevitable in the workplaces. And discussing that, we still have Yemi Olaniyo, Esquire, the lead partner of Lehi Attorneys. Thank you so much for being here.
Thank you for having me.
So now, before the break, I did say that he offered legal advice, free legal advice on this edition, and which is rare. You can't get that anywhere except on Law and Order. But we're diving into the Employee Compensation Act right now, where you could be compensated or given something if you get injured. That's when you're dispensing your duty in your workplace. So the Compensation Act, as regards to employee, how does it work?
Okay, so you have the Employee Compensation Act. It came into being in 2010.
Okay.
So it's closely tied to NSITF, that's National Social Insurance Trust Fund. So the idea is if an employee gets injured in the course of his employment, then he's entitled to certain benefits from the board of the fund. So Section 7 to 11 list out the various injuries. So interestingly,
that's a section from the Compensation Act.
From the ECA, yes, the Employee Compensation Act. So it lists out certain general coverings that to apply to. And interestingly, one of them in Section 8 is mental stress.
Okay.
Yes. So if you're
this is really interesting. It's kind of dicey, but it's very important.
So I won't go into the specifics, right? So the act says if in the course of your employment you have during the course of your employment you now suffer serious emotional stress that affect your health, then you are entitled to compensation.
What kind of compensation?
So now, that would depend on the board and certain factors. So, and what's happened? How did it happen? Did you treat yourself? Was it a pre-known condition? So there are so many variables that will come into being. But now, if we jump to Section 33 of the Act, it provides that every employer must contribute 1.0% of its annual payroll to the fund. So there's a fund that is run by the NSITF.
Okay.
So every employer is expected to every year pay 1.0% into that fund. So 1.0% of your total payroll.
Okay.
Payroll for whatever your employee. So if your total payroll is 1 million, you're going to pay 1.0% of that 1 million to the fund. So where your employees now have issues or have difficulties or are faced with certain challenges that affect their health, then that fund can be accessed. Now, but interestingly, I think it's Section 7 that says that you must, I think Section 4 that states that the employee or his dependent must apply for that fund or apply for that compensation within 14 days from that from the accident. But now, obviously, there might be some give and takes. Assuming you could not make the report within 14 days, you must be able to give sufficient reasons why you are unable to make that report within 14 days. So the report is to be made to the line manager, supervisor, to the board, then the board now remits it to the commission and all that. So yes.
So you talked about the time frame being 14 days.
Yes, by the Act.
So all of these conditions and all of the sections you quoted from the Employees Compensation Act, is this supposed to be included in the employment contract? Is this something we should look out for when we receive employment letters, going into signing employment contracts?
So most employers, it might not be in your employment contract, but it could be in the company's handbook or in memos that the company would issue subsequently. Some employers include in their employees contract, but since the money is not being deducted from the employee's account, it is strictly to be paid by the company. So the company might not tell you that there's this, but obviously when they open the account for you, they will obviously let you know that okay, we have so and so amount with the NSITF. But the company it might not be in your employment contract. It can be, but the law doesn't say it must be.
Okay. So you talked about the company's handbook. A lot of us take it for granted, and a lot of us just think that it's just a handbook. We just go through it. Maybe the most important part is when to resume work, when to close work,
and your pay.
And your pay. Interestingly, but you mentioning it on the show right now in line with having your compensation and if it should be included in your employment contract. It just strikes something that the handbook is very important in a workplace. Is this statutory? Maybe if you're building up a case against an employer, can you bring in the handbook as, just stated that it's in the handbook. I can actually, sue this person because you're not following the rules or you're not keeping to the end of the bargain.
Okay, this is the part where you pay consultation fee.
Okay. Consultation. Okay. I think we'll have to talk about that after the show. But
Okay, yeah. So that's on the lighter note. The employment handbook is as important as your employment contracts.
Interesting.
Because your employer is going to give it to you. Read this. It contains everything. It contains all our rules. It contains our guidelines. It contains what we are about. It contains what we condone and what we don't condone.
Okay.
Right. So are you going to sign? So most employers will have it at the bottom of it. You just sign. I accept, or I hereby agree to follow the company handbook and so and so and so and so. And then people don't read it. Most times it's a very bulky document. Some companies have it as much as 200 pages, 250 pages, and in very tiny print.
Okay, is the tiny print deliberate?
It's like terms and conditions of everything you're buying. If you buy an item from the supermarket, check the terms and conditions. They're very tiny.
So why don't we petition that they should make it very bold so anybody can read it and understand it?
Competition.
Okay, we can do that. Okay, we can actually do
so
that.
And if you go into an employment and the employment handbook is very small, you can say, oh, so I can't see this. Can I get a more enlarged format of the font?
What about an interpretation? Can you ask someone to interpret some of these things?
Yes, that's why you have lawyers.
Okay.
So you can meet your lawyer and say, okay, I'm a lawyer, this thing, can you help me explain? So I have a couple of friends that have worked out to me that, okay, this contract says this and this. What does it mean? And then, question my friend obviously would oblige you. So yes,
That's when you see words like indemnify and the rest of them. And then you're wondering, what does this word mean? So it's very important, just like we have doctors, family doctors, it's very important that we have lawyers in our lives. You know, you're like a personal lawyer you can call. Even with before signing the document, you know, I think we've come to that era where when you're going to sign your document or collecting your employment letter, you should come with your lawyer. Like sit down on the round table and then, you know, read these things and then append your signature at the end of the day.
I remember something now. So someone says three people you must have in your life. It's like your pastor, your imam, your doctor, and your lawyer. Three people that you must have and you must never lie to. If you lie to your lawyer, you might go to jail. If you lie to your doctor, you might die. If you lie to your imam or pastor, nobody might be there to pray for you or to intercede for you. So you must have those three people in your life. So yes, it's important that you have your lawyer to consult. A lot of people, I still have friends that make a lot of mistakes. They sign documents, and when the mistake has now confronted them, they say, "Oh, Yemi, come and help me." And I'm like, "But I have been here. You could have asked me to review this document for you and give you my opinion on this document, but you refused." So people feel like it's not just law, it's not black and white. English, man, come, go. So I don't need a lawyer to come and explain to me what man. But the lawyer has been taught over years that black and white most times is never black and white. Black and white sometimes, if you mix the black and white, they can be brown or yellow or purple. So that's what the lawyer is trying to see the other colors. While you are seeing black and white, the lawyer can be seeing pink.
So this is how important it is to review before appending your signature on any document that is work-related.
Even if we move away from work-related, every document you should
have...
for
the context of the show.
Yes, for the show, yes. I mean, yes, since we're talking about employment law, every document your employer gives to you that relates to your employment, you should look at it. Call your lawyer to look at it. How does this affect me? So the document might not affect you now. It could affect you next 5 years or 3 years. Maybe when you're looking for a promotion or a salary raise, and maybe it says, "Oh, no matter how hard you've worked, you're not entitled to a salary raise until 5 years, and maybe you need a salary raise in 3 years." And then when you go and you need to read your handbook, it says 5 years, and then you're stuck.
But is there supposed to be like a window for review? Maybe before you append your signature, it can be negotiated.
Yes. So most employers will tell you, once you have done your interview, they will tell you, they will most likely communicate the terms to you via mail or via post. And they will tell you, accept this within 7 days, or accept this within 14 days, or accept this immediately. Beware of those that say accept it immediately. Because it doesn't give enough time to look at the employment contract and say, okay, I'm okay with this, I'm not okay with this. So I had a friend that got an offer from an organization, and it was a good offer, but she knew she could earn more. She knew her worth, and she wrote back to them and said, "No, I can't take this. I want this to be in line with so and so." And they agreed with her and increased the salary, sent her that offer letter, which she accepted. So you must not just take it because that's what you have been given. You can request for more.
So the Employee Compensation Act, we've had cases where people try to ask for compensation. We've had cases where people lose loved ones as a result of, work hazards in the workplaces, injury and all of that. And they're not being compensated, even as we're speaking. So what should they do? How should they go about seeking redress?
So they need to go back to, if the person is late, his former place of employment and apply for the compensation. So, for example, if it's issue that relates to pension, but first of all, they must have gotten letters of administration if the person is dead.
Okay.
If the person did not have a will, the person did not have a will
what
before he died.
What if the person is sick or maybe injury at the
and
hospital?
All that. So they could write to the employer that this person is sick, and as long as that sickness was caused by the job of the employer during the person was carrying on official business. So there's a story where the employer sent the driver to go and get document from somewhere, driver now made a diversion, went to go and went to go and drink, and then a fight broke out, and they broke his head, and the employer now wanted to come and claim from the employer, and you are taking a diversion from where they were sent to. If something had happened to you while you were on that way, on the natural course where you were sent to, fine, but you now take a diversion, went to go and be drinking during office hours. You cannot come and claim from the employer. So yes, the dependents can write to the company stating that this person has been injured, have evidence that the person has been injured, and it was the job that caused that injury.
Okay, all right. So the person can get compensation, but is it a civil matter? Is it a civil matter?
It's a civil matter.
So you don't bring the police into it?
Yes, but Nigeria, people like the police.
Sometimes you're asking for compensation and you don't get it. You feel frustrated at some point. You just say, okay, the next thing to do is invite the police or involve the police.
That's why you have the courts.
Okay, so the court handles it.
Yes, you can approach a court of law that this person's right has been infringed, or you write to the you write to the commission that's supervising wherever you're working.
Okay.
Write to them that my employer has done this. So you try to explore all civil opportunities or avenues before saying what's going to do. Police is not a civil matter, and a lot of people abuse the Nigerian police force a lot. Nigerian police force strictly does criminal matters that have criminal nature in them. But this is purely civil matter. It's a contract. Basically, your employer has breached your contract impliedly or expressly. So the best way is to meet your employer first. If your employer doesn't budge, then you approach a court of law. That's why they will have the courts.
Okay. All right. Time would not let us continue this conversation, but I hope that in our subsequent episodes we'll be talking more on the Employee Compensation Act and everything that has to do with the Compensation Act. It's a vast document, and it'll take hours for you to go over it. But thank you so much, Yemi Olaniyo, Esquire, lead partner of Lehi Attorneys, for being on the show today.
Thank you for having me.
And it's always a pleasure having you on the show.
Grateful.
And this is where we draw the curtains today on the show. But remember that where your rights start, another person's rights begin. And it's very important that you know your rights, because you're not having maybe knowledge of your rights or not knowing what the law says about a particular situation is not an excuse in a court of law. So it's very important that you know your rights. For you to watch this program, maybe this particular episode or other episodes, all you have to do is get to our YouTube, Trust TV, and /Law and Order, and you can watch the program again. Recommend to friends, like and comment. If you have questions, please put them there. If we need to bring the lawyer back to the studio to answer these questions, we'll do that. But thank you so much for being a part of the show. For more updates, visit our social media platforms. I am Martia Umar. I'll see you another time.